And then, all right, I'm going to start the broadcast. All right, hello everyone, and welcome to our webinar for today. We're just going to let folks flow into the session, so we're just going to hold for a minute or two while everyone's getting settled. But while we're waiting, thank you all for joining us here today for part of the TechOwl and Institute on Disabilities at Temple University's National Speech Language Hearing Month webinar series. We're glad to have you join us throughout May to learn about all kinds of different AAC related topics. All right, so I think we can go ahead and get started. So today's topic is the right to not remain silent, AAC in the court and legal system. So we are going to be talking about just that, the court and the legal system and how AAC and other assistive technology kind of relates and can be used within these larger systems. So just some logistics for the webinar today. Live transcription captioning is available using your Zoom controls. So if you need that accommodation, please feel free to turn that on. If you're not seeing that option available, you may have to update your Zoom to the latest version. We also are going to be able to answer questions today, so please feel free to type those on into the chat or the questions in the Q&A, and then any comments or things like that, you can feel free to put in the chat as well. We will be monitoring both throughout the session. We do plan to have some additional time at the end for questions as well. And if we're not able to get to all the questions or you don't want to share live, please do feel free to email any of us. We're happy to continue this conversation going and discuss that with you at a later time. Also, at the end of the session, we will provide information about certificates for attendance for the webinar. To receive a certificate, we do ask that you are present here for the entire webinar, and we do have to verify attendance with the Zoom record to be able to honor those. Okay, so our learning objectives for today, this is kind of like the bare minimum or the main takeaways that we hope you get out of today's session. So we're hoping that folks will be able to describe at least two ways speech language pathologists and of course other AAC stakeholders can advocate and support AAC users involved in the legal system. We hope that you're able to learn how to develop at least two rationales to support access to court and justice related vocabulary for AAC users, and that you're able to then recommend three or more examples of phrases for self-advocacy related to the legal system. So both vocabulary, single words, as well as more phrase-based vocabulary. So if you've joined any of our sessions over the past few webinar series, we've talked about extended vocabulary access for AAC users, such as looking at things like profanity, slang, and sexual health vocabulary. So in a way, this is a continuation of that discussion. One of the key points that we've talked about in those presentations is the importance of access to such vocabulary to support better outcomes for AAC users in preventing abuse and in their self-advocacy. So that's only one part of the discussion and the mindset that needs to be changed. We really want to also make sure that we are setting AAC users up to getting greater access to this vocabulary. But then we also want to take a look at, once we have access to that vocabulary, can we actually use it when it counts? But the reality is that in the court and the legal system, it's just not inherently accessible. In fact, there's many barriers that exist, and unfortunately, accessibility, particularly communication accessibility and accommodations, are after or an afterthought. But how we can work to overcome that as an AAC community and community of stakeholders and users and supporters, that's really the goal of today's talk and today's discussion. So, about the words that we'll be using in this presentation, please keep in mind that I am speaking from the perspective of a speech language pathologist. I consider myself someone who specializes in AAC, but I am not an individual with lived experience. Am not an AAC user myself, so I do highly recommend, if not insist, that you do seek out the works and perspectives of AAC users and others with lived experience in the disability community, not just about this topic, but about other topics as well, to help you form a more informed opinion and viewpoint about this type of content. I'm also going to be using a variety of identity first and person first language, and I'm doing that to be able to honor both preferences for how folks like to talk about and refer to themselves. So you'll hear me say AAC user, person who uses AAC, disabled person, person with a disability. Also, there's a lot of different words that people who use communication devices like to refer to themselves. So we have here a list. This is, not all the types of identity vocabulary here, but just some of the words that you might hear me say. AAC user, communication device user, non-speaker, non-speaking, non-mouth word user, people who cannot rely on speech alone to be heard and understood. So there are lots of preferences that folks may have when referring to themselves. So a content warning, this presentation will discuss and include explicit language, sexual health terminology, references to abuse and violence, and then also talking about legal proceedings, including injustice, crime, and related situations. This presentation is also going to contain images later on, looking at symbolizing and how we can represent this type of related vocabulary on our AAC devices. So there will be some pictures related to reproductive and sexual anatomy, potentially sexual health and activity, as well as abuse and violence. If you also then go on our website and look at presentations that are kind of offshoots of this one related to extended vocabulary, you will also see images and text with explicit language on there as well. So just keep that in mind today. Please take care of yourself if any of the information is a little too heavy and you're not in the right listening space for that. Please just be mindful. You can always come back to the content. We will be recording today's session as well. And another disclaimer. We have lots of disclaimers around here. So this presentation is by no means any form of legal advice. I am an SLP. I'm a speech language pathologist. I am not a lawyer, so I am not an expert in the law. I'm just someone who's passionate about this topic and also then noticed a gap in my own personal knowledge in this area, as well as in our field of speech pathology and assistive technology in general when it comes to the courts and the legal system. We also, myself and my other SLP colleagues, we work for Pennsylvania's State Assistive Technology Act program. So we've actually had to answer quite a few calls where someone is reaching out regarding an assistive technology question for the legal system. So we've had to answer questions related to incarcerated individuals, actual courtroom proceedings. I've even assisted with forensic interviewing for a semi-speaking child survivor of abuse. But these were situations where myself and my team, we often felt stuck. There weren't really straight answers that we could provide to the folks who were coming to us for advice or for suggestions. And It's really kind of because of this concept of accommodations for disability and assistive technology in the wider justice system are often not established or clearly documented. It's a little challenging for us to get a request from the court system themselves asking what types of accommodations that they need to support when we're not necessarily sure either. But really, the standards too of is considered acceptable varies from jurisdiction to jurisdiction, from state to state, and even from situation to situation. So this presentation overall is really meant to just be informational purposes to really kind of start a larger conversation. I'd also love to hear from the folks that are attending today about your experiences dealing with AAC and assistive technology in the legal system so that we as a community can continue to learn more. But if you have a specific question or a specific situation, please consult with an attorney so that you can receive that proper support when navigating the legal system. And also keep in mind that just because someone is an attorney does not mean they are your attorney. So always be careful. And then once more, this is not in no way should be considered legal advice, not legal advice. So just a brief overview of AAC. So what is AAC? This is augmentative and alternative communication. This is for our purposes here today, we're going to really be focusing on like communication devices themselves, especially when we're looking at how vocabulary is represented. But AAC essentially includes any method of communication beyond oral speaking. Oral speech, oral speaking, and talking. So things like gestures, facial expressions, writing, drawing, texting, emailing, using pictures, symbols, using a device, all of those can be considered forms of AAC. And we all use different forms of AAC throughout our day in our communications. So here's just a sample of what the AAC continuum can look like. When we talk about assistive technology as a concept, we use this idea of lower light tech, mid tech, and high tech. And we might talk about it on a hierarchy kind of scale. It doesn't mean that one system is better just because it's considered a high tech system than a low tech system. A lot of folks may use a variety of these types of devices. Some, a light tech system using writing, using a picture board system or communication board, that might be considered a light or low tech system, but it might be the right system for an individual. It doesn't mean it's inherently lesser because we're using words like low or light. So just keep that in mind when we are talking about devices, that AAC is a wide continuum and there's lots of different types of equipment that folks can use. AAC user profiles. So a person who is an AAC user, they may use their device all the time and need that for speech, and that's their primary communication mode. Sometimes folks may only use it some of the time. And so we're really considering AAC when a person's functional communication needs, for whatever reason, are not being met across all of their daily activities with all the people that they need to communicate about in the different environments that they need to communicate about as well. So oftentimes a person might be experiencing a lot of frustration. Other folks are having to guess maybe what their gestures or their communication modalities mean. So that's where a device may come into play and be helpful for a person. So oftentimes too, AAC users talk about that their speech, it may, whoops, I went ahead, that their speech may be unintelligible, unclear, difficult to understand, also intermittent, unreliable, or insufficient. So folks that use AAC may be able to speak. Some may not. So keep that in mind that every AAC user looks different in terms of how and when they may use their devices. I've also included here the Communication Bill of Rights, just for folks to have access to. But if we take a look at this, we see a variety of different concepts that kind of we really want to keep in mind. Um, from this viewpoint, we're really looking at communication as a human right and all of the things that go into this that folks should be able to have access to. So the right to dignity and respect in all interactions, the right to individualized working AAC systems and other AT at all times. And so that's one thing that we might not see is being able to have access to your AAC or your other types of assistive technology when in the legal system. And so what that looks like. So just keep this kind of at the forefront of your mind today. So a little bit of defining concepts to kind of continue this building our framework for our discussion. So some key terms here. So precedent and competency are two terms that really come up in a lot of this when we're looking at the literature and related research into disability and legal proceedings. Now, these definitions here I have on the slide are not the super fancy detailed ones that someone in law school or a legal professional would give you. So for our discussion, we're really just going to keep things simple. So precedent here for our purposes, it's really going to be how a court decision impacts other decisions and cases. And so a case can set precedent, meaning that it sets a standard for then how future similar situations and cases are going to be handled. So for example, if something was allowed in this case, then it could be argued that it should be or may be allowed in other cases. One example of this, there was the case of Ruby McDonough out of Massachusetts, and Ruby was a woman with aphasia, and she was initially deemed not competent to testify. But this was later petitioned, and her competency and ability to testify were then later reinstated. But the literature described that there were concerns from both the prosecutor and the defendant sides that should the decision be overturned, it would set a precedent then for how accommodations for people with disabilities would then be handled in that state. In 2010, the Massachusetts Supreme Court ruled that, quoted in Boswell 2011, if you want to read more about this, quote, Ruby's rights had been violated and established new rules that provide a right to accommodations to ensure that witnesses with disabilities are able to testify. So just kind of think about that. So this case helped set that precedent for getting those accommodations to support communication in legal proceedings. So another term that we hear a lot or we see a lot in the literature then would be competency. And this can really be a loaded word. A competency specifically related to standing trial and testifying is different from what competency is in other legal situations or settings. For example, like determining legal guardianship of a person with a disability. And it's really different too from the societal perspective and definitions of what competency is, like when we think of things like presuming competence that we use a lot in discourse in the disability community. Brian and Wickman in 2011 analyzed federal and state laws and found that people with what they describe as, quote, with little or no functional speech were presumed competent for court proceedings when they, quote, have the ability to communicate what they saw, that they perceived what they will testify to, whether they had the memory needed to recall and communicate what happened, and that they understand the implications of the oath. So overall, their findings really described that just because someone has a speech disability, it does not automatically rule them as not competent. So when we really look at the legal system and what goes on in a courtroom, it is highly based on communication. Communication plays a major, major, major role in our legal system. And really the language that's used within legal settings and situations requires a high level understanding of complex and abstract language for someone to be able to participate. If we view communication as that human right and advocate for vocabulary access for AAC users by providing words and phrases needed to talk in court, that really only does us so much good in the arena, especially if the arena itself isn't accessible and then doesn't accommodate or allow those accommodations for the AAC users' actual participation. So this slide here just lists a few examples of where communication is necessary. So, such as speaking with police, whether that's to answer questions because you committed and or are accused of a crime, or you're reporting an incident or a crime that happened to you or that you saw. Um, Another example, obtaining and completing paperwork in legal settings also requires communication. So, for example, I needed to swear or attest to something when my husband and I we went to the court office for our marriage license. But if my swearing or attesting wasn't in oral speech or the conventional method that the folks working at that court office expected, would the process have gone as smooth, or would there have been extra steps I needed to take? So the need for accommodations isn't often addressed until it is needed. And sometimes then it's a little too late and it can create barriers. Another example is that being able to participate in court proceedings, whether that's testifying or even participating in a jury, that also involves communication as well. So now most people don't like to get jury duty and dread getting a summons, but that is the opportunity for participation right there. The right to serve is there. So AAC users and folks with disabilities also have that right and should be able to then receive the accommodations that they need in order to participate in their civic duty as well. So here on this slide, we're going to take a look at that pretty famous example that you see in all the court shows and police shows. So the Miranda rights. So you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand the rights I have just read to you? With these rights in mind, do you wish to speak with me? When we look at this, the Miranda warning from a linguistic and SLP lens, there's a lot going on there. Studies are reporting when they look at this and analyze this that it's kind of falling around a seventh grade reading and listening ability for someone to fully comprehend this warning in the words here. These studies that kind of analyze this, they go on further to describe then how people with language and communication disorders often then do not understand their rights. And this can lead to situations where then people's rights are being violated. They may be coerced into providing a false statement or even a false confession. And if you are using an AAC device, do you have the vocabulary access to convey that you do not understand or that you want an attorney? There's many cases where law enforcement may have mistaken a communication disability for being disorderly or drunk or something worse. And unfortunately, we've seen these outcomes in the real world, and they often end up being horrific examples that illustrate injustice for disabled people. So here's some more information that really looks further into this idea of how communication disabilities can really impact somebody's access to justice within the legal system. So 1/3 of law enforcement professionals associated a person's language skills with their credibility. So if we apply that to a real world example, we could really assume that a person who can't use oral speech may be more likely to be determined that they aren't credible. We could even go as far to assume that because they can't describe what happened with speech, that according to some law enforcement, that means that this isn't true or that the event, the situation didn't even happen at all. Another interesting tidbit from the research that I'll mention here is from an article by Benz and Lund in 2024, so hot off the press-ish. So they collected information from different law enforcement professionals, and many of their respondents supported accommodations for people with communication disorders, but their results showed that there were some law enforcement who were actually strongly against it. And it was significant enough for them to mention that in their article. And from those that were against the accommodations for communication disorders, they described a quote, limited subset of law enforcement professionals who believe treating everyone the same was more important than changing services to ensure equal understanding, or as they clarify, accommodations. So appropriate accommodations are important and necessary for people to be able to participate in situations to the best of their abilities. Anything less than that begs to question if people's rights are then being violated. So I'll be honest here, it's really, really hard to get a straight answer on online and when you're like looking about what these accommodations are that are allowed in the American legal system and in the courtrooms for people with disabilities. So some county courts describe having assistive technology available in certain rooms or in certain buildings. Others just list an ADA, Americans with Disabilities Act contact. So if you ask what's allowed, the best answer that I currently have is it seems to depend. And I know that that's not a great answer, but that seems to be the going one right now. And that's also where that idea of precedent really comes into play, especially for those very specific accommodations that someone with a communication disability might need. The common term used to describe these accommodations is auxiliary aids and services. So some examples of auxiliary aids and services, it's pretty vague and it's really open to a lot of interpretation. Online, you're going to find some examples for communication disabilities, and they describe accommodations such as things like speech-to-speech transliterators. So this is someone who will repeat word for word what a person with unintelligible speech said. Other things like real-time captioning and extra time if maybe a person's using a communication board. So communication boards, quote, get a shout out. So that's nice to see. And we can use that to argue that AAC is described, but again, it's extremely vague and open up to interpretation. So does that communication board mean? Up to interpretation there. I've also learned a lot about how the legal system does things. Again, really up to interpretation, and that's, probably not the best, and it's often up for debate, which kind of is on theme. But overall, if accommodations for communication needs are listed or described at all, they tend to consist of a guidance for communication accommodations for folks who are deaf and hard of hearing. So that's really what you're going to see when you look up the accommodations for the different court systems. On this slide, too, is also a photo of the McLaughlin courtroom. And so this is from the Free Center or the Center for Legal and Court Technology at William and Mary Law School. And it describes itself as the world's most technologically advanced trial and appellate courtroom. So it features a lot of really advanced and more modern technology examples, and they also reported that they have a lot of equipment for folks with limited vision and vision loss. So a specific case mentioned that this courtroom has that technology for supporting folks with hearing needs. Another example was that they used this courtroom for somebody with a macular degeneration, but then specific information on what those assistive and adaptive tools that they used, that wasn't really available, and it wasn't kind of easy to find online, meaning I did not find that in my search. But this is a nice resource to kind of like peruse and see that there are or how other folks in different states may be using AT and technology within their courtrooms. So this slide here is going to outline just a few cases of interest where disability and accommodations were described or mentioned. So People versus Augustine from 2023, this case determined that just because a witness is difficult to understand does not mean that they are inherently or automatically incompetent. So kind of going back to that earlier case that we looked at when we were talking about precedent and competency. People v. Miller, 1988. This case talked about the use of a speech language pathologist being used as that speech-to-speech transmitter for the witness. So in this case, the SLP gave a word-for-word repetition of what the witness with cerebral palsy was saying. So they were not with this. There's information when you like research into speech-to-speech transmitter services that they're really not supposed to add any additional context. They're just supposed to repeat word for word what the individual is saying. And then here also breaks down that case we took a look at, Ruby McDonough's case in Massachusetts. So just to recap, she had an expressive aphasia and could answer questions using gestures, and she could respond to yes, no questions. However, she was not initially provided these accommodations and then was determined not incompetent and therefore was not able to testify for herself. So when this was appealed and then it got bounced around the courts a bit, eventually her competency to testify was reinstated and she was then given her accommodations. All right, so taking all of that information and that kind of framework and those case examples, and now we're going to kind of apply that to actual AAC. So why is this important for AAC? Why should we care or even talk about this? And that goes back to that idea that AAC users must be able to exercise their right to communication, and that includes being able to communicate and participate in the legal system. So AAC users must be able to report abuse, report crimes, testify as a witness, testify on their own behalf, and they have the right for their day in court, just like anybody else does. Um, but unfortunately, the statistics are really against us. So people with disabilities, especially those with severe speech and communication disabilities, even though the statistics here are a little outdated, unfortunately, we're still seeing the same pattern. Folks with these disabilities are more likely to experience abuse and experience crime against them. So the studies here listed that a pretty large percentage of folks who used AAC had experienced crime, but then only a smaller percentage, only 28% of those in that study reported to police. We're also seeing too that then AAC users often report then that they do not have access to words related to like healthy sexuality, body parts, as well as other taboo kind of explicit topics as well. And a lot of times that vocabulary may be needed in order to report those instances of abuse or violence crimes. But when that vocabulary is not there or it's not on the system, really, how can that person advocate for themselves and their justice when communication is really such a key part of that? So if you don't have the words to report that something happened to you, how can you report that it happened? So our implications here as well, some studies looked into the accommodations that were requested, and AAC was actually one of the most common accommodations requested for people with communication disabilities. And this was across multiple countries that they surveyed within this study. But the information on whether or not the AAC was actually allowed, that was really not available or limited. So I will mention, though, that a lot of this work in this particular area is from researchers in South Africa, and they also do have some like good resources. So at the end, there's some references there. So there's lots of reports in the literature too that specific recommendations or guidelines for accommodations. They're kind of hard to find, but they do exist. But then keep in mind, like what that then looks like in actuality is really going to vary from country to country and across different courts as well. But these are some good resources from these researchers in South Africa related to AAC and justice. So, too, when we look at language considerations, there are some specific recommendations for better success within the legal system when it comes to like programming on AAC devices or related to just like using language. So some of the researchers have recommended, for example, that verbs be in the present tense on communication boards, and then that has to do with the linguistic implications of the use of different tenses and how that can then change the meaning of the utterance as well. And then it was also recommended that questions be in the active form rather than the passive form when interviewing people with communication disabilities. So who hit you versus by whom were you hit? So taking a look at that and how we process language, those are things to also kind of keep in mind and consider when we're looking at accommodations and the complexity of different linguistic structures and then how the brain can process those. So just kind of keeping this in mind that there are differences within language as well. Of course, this may vary if folks are using different languages other than English to be able to report, but here's just some little tidbits to consider. So some more case examples. So these ones here on this slide actually look at AAC, or AAC was at least described in the actual court records. So the first one here from 1989 was Commonwealth of Pennsylvania versus Tavares. Um, I'm probably not saying last names right, so bear with me with that. But in this particular case, the witness with cerebral palsy used what was described as a speak and spell, quote unquote, communication device to testify as a victim of a sexual assault. Um, Another case too, this one's from 1983, People versus Spencer. So in this case, a deaf and non-speaking woman reported that she was raped. She communicated using gestures, pointing, and nodding. And the record described that, quote, because of her inability to speak, she would be using a blackboard containing letters of the alphabet, numbers, colors, picture symbols for simple concepts such as house, and anatomically correct dolls in testifying. She indicated through gesture, pointing to the board, and reenactment using the dolls. So these modalities, by using them, she was then able to retell the events of the crime and the abuse that she experienced. So this defendant did attempt to claim that she could not be adequately cross-examined, though. So that's something, kind of remember that for a little bit later. In 2003, People versus Sykes. So the court describes or the court record describes that a survivor of a violent assault was able to testify using an eye gaze system. The record states the following: Girl X was able to communicate using an eye gaze system. The eye gaze system is commonly used for people who cannot see or hear. The system relies on each individual's yes/no response system. For girl X, her eyes would go way up, indicating yes, and for no, she would shake her head and look down. The alphabet is divided into 3 blocks: A through H, I through Q, and R through Z. A questioner begins by asking if the letter is in the beginning, middle, or end of the alphabet. Then within each block, the questioner goes through the letters until a yes response is obtained. So from the AAC world, or using AAC lingo, we can kind of think of this as describing a partner-assisted scanning modality here in this case. And then Ritchie versus People. And so this one's from 1896. So the witness here in this case was reported as deaf and non-speaking, but was able to testify through reading written questions and then responding via writing himself. So then his answers were then read aloud to the jury. So here we're looking back into, over 100 years ago that AAC is actually described in some of these court records as being available, being a tool for or an accommodation for folks to use to be able to participate in court proceedings. So when I summarize the 6 to 7+ pages of references that we have here today, it unfortunately left me with more questions and thoughts than actual answers. But here are really kind of some takeaways to think about. So there really is, when we look at all of this, a lot of limited knowledge of communication disabilities and just AAC in general by legal professionals, whether that's lawyers or police, folks at the county clerk's office as well. So what can we do as like stakeholders, as users, as advocates to help change this? Do we have more trainings? Do we spread the word? Do we create more resources for like light tech systems that can be easily used by police or other first responders to have available? I don't have the answer here to this. This is me kind of throwing out ideas or thoughts to the community. I'd love to hear or see other ideas to kind of overcome some of these barriers. If you have them, please feel free to put them in the chat. Another big thing that we see in some of these discussions too is the question of authorship when it comes to using AAC devices. One thing is really that the other person's lawyer often brings up different arguments that then can add to the element of reasonable doubt when the words are from a device and questioning whether those words are truly from the individual. Now, we know that that's not true, but the court doesn't always agree. And there were some reports where defense attorneys attempted to say that pre-programmed words and phrases on a speech generating device were hearsay because they weren't generated live. And that's a strategy that a lot of AAC users would use to pre-program larger productions of speech so that they don't have to generate that in the moment so that they can hit one button instead of having to type out or use their symbols to generate a full paragraph. They might have constructed that message earlier. But then it's opening up the question that are these their words or did somebody else assist? Did somebody else help? To my understanding that these particular situations or arguments, they were dismissed, but it's interesting to kind of think about that they were brought up in the first place so that this questioning is there. I've also really seen this is vocabulary being then added after the fact. So like after a situation to a person's device, you're kind of opening up a can of worms or kind of handing a potential argument for leading the witness that like, oh, this person didn't have, words related to crime, or if somebody was sexually assaulted or abused, that they didn't have access to body part vocabulary on their device. And now after the fact, they do have this vocabulary. Well, why? Is somebody coaching them? Is somebody telling them to say these things on the device? So those are kind of things to think about and why we want to provide access both receptively and expressively to some of this content, especially related to bodies and personal safety. And then two, this kind of goes back to this hearsay argument, but if a person using a speech generating device doesn't use generative language, like single words, and they're piecing together longer sentences or productions, but they're needing like phrases, they're using picture supports, does this like do these aspects of their system impact their ability to be cross-examined, and then it infringes on the right of a defendant? Um, so again, no magic answers here, but things to really consider that are potential barriers here when we're looking at using AAC and how we can do better. So the next couple slides are really going to take a look briefly at the different availability and the different access that we do have from some of the popular apps just right out of the box when we download them. Of course, we know that most of our speech generating devices can be customized and should be customized to include some of this vocabulary or phrases, all that good stuff to be able to talk about these types of concepts when we need it. But that's the kind of the thing here when we're looking at taboo language, explicit language, curse words, sexual vocabulary, things like that we don't think about until after the fact that we needed it a little bit earlier. And then that sets us up for back to that potential hearsay that, oh, or is this person being coached? Especially for folks that may need supports in programming their device, or for folks that do not have literacy skills. There's lots of considerations. So some of the companies are starting to have this type of vocabulary or this content readily available by default on their systems. So disclaimer here, a lot of the samples are going to be from Grid. We will take a look at some other ones, but Grid does a pretty good job with kind of including some of this information in their default vocabulary files. So here on this particular slide is an example from Grid and their vocabulary set VocoChat. And it takes a look at vocabulary for reporting. So when we look at VocoChat, when we hit the button something is wrong, and then we can go to something happened, now it gives us options to talk about something. Well, what happened in these are, set up to be more like negative situations here for that scaffolding of this conversation. But we have things like someone called me names, someone hurt me, someone touched me, someone stole something. So these are, already pre-programmed on there to be able to help somebody with reporting an instance, that happened to them or something that they saw. Another example from grid. So this is looking at super core 50. So vocabulary that's pre-programmed to talk about race, diversity, and justice. So you have some of those topics related here as well. We have things like equality, we have inclusion, exclusion, justice, discrimination, abuse. So those types of words, again, pre-programmed and symbolized on the device here for that type of participation. Of course, this can be expanded on to better accommodate a person's identity and the words that they may need, but it's a great starting point as well. Another example too, within Supercore 50, so some vocabulary particularly related to the court and crime legal systems. So we do have these words, a lot of them are listed here as single words, but single words we can often go a long way. We can use those, within our generative language as well. So there is that vocabulary to get started for someone to be able to participate here. So just taking a look at how some of these images or these concepts can be symbolized on AAC devices. Again, I said we were going to look at a lot of grid examples. So their vocabulary for life, if you tap safety, and then it'll take you to a page for danger. So this has some phrase-based examples. So someone is acting suspiciously. I have been robbed. I have been attacked, and then some related place or folders that then can lead to. So like danger, I like that there's an alarm on here as well to do that. 911 for emergency. So not just being able to report, but then like be able to, tell somebody we need to call 911. What is the resource that a person may need to use to actually report an instance that's happened to them or that they witnessed? So taking a look at how this page set is set up kind of gives you some ideas for how to set up other folders potentially. Grid vocabulary for life as well. So this is vocabulary for emergencies. So this is just, again, the default files, no particular edits made here. But there's some good language, good phrase-based language also set up. Call the police. I need an ambulance. And then also my name is, and then you fill in the blank for your personal information. That can be really important for reporting in an emergency case. So some more examples from some different apps as well. So from TD Snap, we can see here's the default emergency topics pages. So some phrase-based vocabulary, and then also some of that more single words, short phrase vocabulary too here. And then TD Snap also has under supports, they have a script for being able to report a robbery as well as like the step-based one with like this using like that schedule or the visual schedule format for how to report an emergency. So to help somebody who may need those additional supports be able to do this a little more independently. Other apps as well as the ones I showed here, Grid, Tobii Dynavox, they also have a lot of vocab in TD Snap as well as in Grid. They have a lot of vocabulary pre-programmed related to body parts, sexual health already within their systems by default. Some of our other apps, you have the option to add those, like the symbols are available. You do have to just go in and purposefully, intentionally add some of those to your page sets. But that's something, to consider as well. Word choice is a personal choice, but it is nice to see that we are seeing some changes, that some of this vocabulary and these concepts are more readily available on a lot of our systems and devices. So some final thoughts. We talked a lot. I didn't have a lot of answers for how we actually go about this, unfortunately. But I think that's kind of what starts we have to start the conversation and then advocate for change. But overall, kind of the final thought or takeaway here is how do we improve AAC user outcomes for participation in the legal system? Just overall, how do we better support access to vocabulary for, somebody's entire life? What that vocabulary looks like, what are those words that that person needs to be able to participate in all the things that an adult, a human needs to be able to participate in. Again, I don't have the magic answers, but I'd love to hear from the community if anybody has any thoughts or ideas or questions. We'd love to hear them as well. Yeah. And then, as promised, a bunch of references for you today. If you download the slides, you will then have access to this reference list. So not everything was necessarily here mentioned, but a lot of this also framed some of the overall work as well. And then just a little bit of an overview. So I did mention that we are TechOwl. So we are Pennsylvania's Initiative on Assistive Technology was our past name, but we are Pennsylvania's Assistive Technology Act program. And we are a program of the Institute on Disabilities at Temple University. So we at TechOwl can be a resource for questions and information related to assistive technology. But as you saw today, sometimes we unfortunately don't have the magic answer. But we will try our best to help you find a solution and navigate the systems. And sometimes that might be saying that it's not that you're, asking the wrong question, it's that the answer doesn't exist. But also, some of our other projects, we at TechOwl have the Assistive Technology Lending Library. So that's where folks can request and borrow assistive technology devices, including communication devices, to try out and see if it's a good fit before committing to making that purchase, because we know a lot of assistive technology can be very, very expensive. Other states have AT Act programs. So if you're joining us from outside of Pennsylvania, your state has a program similar to ours as well. That can be a great resource for you. We also provide at TechOwl in Pennsylvania device demonstrations, different types of trainings. We have some programs as well to help folks get free equipment. There are different eligibility requirements for there. We do provide emergency preparedness supports and programming. We have a reuse program where folks can donate gently used assistive technology, and then we, along with our partner programs, try to help find those devices some new homes. We also can create 3D print different types of assistive devices and send those out. And then if you are local to Philadelphia, a shout out to the TechOwl community space that's located on Temple's main campus. You can come stop by during our open hours and take a look at some devices, try some things out. Here on the slide is a picture of folks at our community space using some of the adaptive video game equipment. We also have different events throughout the month posted, so feel free to follow our socials to see any new offerings that we might be having, whether that's online or in person at the community space. And here are our socials. We do have a pretty pop-in TikTok, so highly recommend if you're on TikTok to follow us over there for some continued learning for assistive technology. And then we do post a lot of our events on our other socials as well. Here is the general information for TechOwl, our 800 line, where as long as it's in business hours and they're not on the phone or busy, one of our staff members will be available to help answer questions, provide some additional resources. We also have our email. You can send us emails and we'll put you in touch with the right staff member to assist, and then the general TechOwl website. And then here's the contact information for Temple University's Institute on Disabilities, which is a part of the College of Education and Human Development. Okay, and then we hope to see you at our next webinar. So that'll be next Wednesday at noon Eastern time. So that'll be May 20th from eye gaze to IEPs, your questions answered. So our colleague Jen will actually be taking some of the questions over the years that we've gotten on our surveys and feedback forms and answering those. So kind of a little snippets and variety of AAC related topics. But these were questions that folks who've attended webinars just like today have asked. If you do fill out our survey that I'm going to show in a minute, if you do fill that out there is a spot for you to share different topics. You could type in a question that you might have, and there's a good chance that maybe we'll be able to answer it at our next webinar. And then our last webinar to wrap up May this month will be on healthy consent and boundaries for AAC users, a DICE activity, and more. So this will be led by our colleagues at the Institute on Disabilities, Nova and Izzy. So they'll be joining us to share information about their work and some different projects and strategies and tools. So please feel free to join us. We'd love to see you there. And we do plan to have these webinars recorded as well and eventually posted to our websites. And as promised, a certificate and survey. So if you do need a certificate of attendance for today, you do have to fill out the survey. So you can either use the QR code or access the link. So please complete the survey. You must have attended the entire webinar for that. And please do allow up to a week or so for us to get those certificates over to you before inquiring about where's my certificate. We promise we will get them to you. If it's been more than a week, then that's when we probably have missed you. And please note that we do ask that you fill out the survey, I'd say, right now or as soon as possible. We cannot honor a certificate request that's kind of come in later or a week after the webinar. So just please try to complete it as soon as you can, and we'll make sure to get that over to you. And if you are requesting a certificate, please do put your name that you want printed on the document as well as the email in which to send it on the form. Otherwise, I don't know where to send it to. All right, and then here are our emails in case you have any questions, or even if you want to share some resources or experiences that you've had, especially related to the legal system and AT. We'd love to hear, if you're in folks in different states as well, we'd like to hear how things are being done in your state. So please do feel free to reach out to us. Yeah, and I'm going to take a look at some of the questions and chat to see.
We do have two questions, Haley,
Mhm.
in the Q&A. If a judge or judicial staff member or lawyer needs an assistive technology device to use for a client, what is the process to consult with someone on the best technology for the situation? Who do they contact? What does the process look like to help the person find the best fit?
So that's a tricky one because we, as the ATAC program, we have been contacted and asked questions. Anybody is welcome to borrow equipment from the lending library in our state. As long as you're in Pennsylvania and it's being sent to a Pennsylvania address, they can borrow that equipment. In terms of specific recommendations for an individual, that's where things can be a little tricky. So for example, as a speech language pathologist, I could tell you which equipment is available or which tools a person may benefit from or be able to use. But because that individual is not my personal client, I wouldn't be able to make an exact recommendation for that person. That would probably be the same for some other professionals as well. If it's for more generic information or generic kind of devices like closed captioning and things like that, what I have seen described is that most, court systems, they have somebody that, is responsible and can, if that's requested, that can be scheduled. But those more specific cases where a person needs very specialized equipment, there's probably a good chance that they should be working or need to be working with a related professional who can provide that recommendation then as the professional that is assigned or working with them. It's a little tricky because of other types of legal things and licensure when as like an SLP, I'm able to make that recommendation and call. Again, that's kind of a non-answer to the question. That's one of those bigger kind of issues that we've been running into. We get that question sometimes, but and then we're not able to actually like provide that answer for a judge or for a lawyer. Um, so that's the best answer I currently have. And then what is the best way to find necessary terms to add to the device if it's not already programmed? My family member has touch chat. Well, in touch chat, one thing to double check, like if there's certain words that like maybe you're not sure if that concept is on the device, you can go into, usually it's under keyboard on on most layouts, that there's like a find word option, and then you can type in the word that you might be looking for to see if it already exists within that vocabulary file. If it doesn't pop up, then that means it doesn't exist and that you could then add it. In some of our resources, there are like different vocabulary lists. One thing too that I also recommend is kind of like seeing like what vocabulary are on other systems. So like the samples that I included from like Grid or the TD Snap app, you can take those vocabulary words or phrases and program them onto a different app as well. Those can be a great place, like those screenshots could be a place starter to give you ideas for a vocabulary list. But things like I'd probably recommend things like body parts. We have some resources on our website as well from some of our other presentations related to vocabulary for profanity and sexual health that has additional samples or examples of vocabulary sets as well as recommendations or suggestions for vocabulary that may be beneficial across the lifespan. Um, yeah. And then there was a question in the chat, one question or observation about the AAC devices with pictures. I noticed the robber had a mask on in several of the pictures. This may be a generational thing, but I've definitely have seen imagery like that. But do kids and young adults today see people like that and associate it with a robber? That's a great question and great observation. I'd probably say the answer is yes and no. It depends person to person. So on these systems, they are a lot of times the pre-programmed out of the box. They are using just kind of like generic symbols to represent concepts, but those pictures can be changed on most devices to put in a better image or symbol that represents that person's association. Um, for that. I wouldn't say that I have like a, better suggestion of what somebody might put there, but that image can definitely be changed should they need to do that as well. Most devices as well you can also import actionable photographs if somebody needs photos and rather than like the line drawing cartoony type pictures. Um, I'm personally like off the top of my head, I'm not really sure what other type of image that I might use to represent like a burglar or a robber um than like the kind of the one you see in like media or cartoons or movies. But that could definitely, of course, be changed as needed. One of the things would probably be more so that keeping it consistent, like we're not changing it all the time once it's established, so the person can learn this button here, it's in this spot, it means this word or this concept. Some folks too may even, you might be able to like take the picture off and use the text and have them be able to learn that association that way as well. So sometimes the pictures don't necessarily matter, but they also they can matter too. It really depends person to person, and then that person's learning over time. And I know we're getting some requests for the survey again. So here that is for you to be able to have access. If anybody else has any other questions or thoughts, please do feel free to share in the chat. We'll hang on an extra minute or two, but that does conclude the bulk of our content for today and for this session. Thank you all for joining us, and we hope to see you all next Wednesday at noon Eastern Time for our next AAC topic. All right. And again, this was not legal advice. All right. Thank you everyone for joining us, and we hope you all have a great rest of your day.